Hello, Dr. Michael Arman here again, and Bernard the barrister bear. Say hello, Bernard. Hello! This video is titled Disarray. You'll see why in a minute. 126 young women and a few men sued Barclays Bank because they claimed that Dr. Gordon Bates had sexually molested them or assaulted them or even sometimes raped them when they came to be examined by him on behalf of Barclays Bank. Now, by the time this case got to court, Dr. Bates was actually dead, and these victims of Dr. Bates were claiming against the bank. Had Dr. Bates still been alive, they would no doubt have been claiming against him also, and there was enough evidence, it seems, to put him behind bars on criminal charges, but he died before any such charges could ever be brought. So the case did not involve him at all, but only the bank. And it is a case of what we call vicarious liability. Vicarious liability, which means that someone carries the can for someone else. And that someone is usually the employer or the principal for an agent, or it can be for one partner for another. Most usually it's in an employment situation where the employer is held liable for the misdeeds of an employee. Now, in this particular case, Dr. Bates was hired by Barclays Bank to do reports on these applicants. These were all people who had passed their first interview with the bank, and all they needed was a clean bill of health to be given the job. He was given special forms to fill in with Barclays Bank heading Barclays Confidential Medical Report. What they said. Each applicant had a report like that filled out by Dr. Bates. And they claimed that in compiling his reports, he had in fact sexually molested them. And as I say, there were 126 young women with a few men who made this claim. Well, Dr. Bates was an equal opportunity sexual predator, so of course he had to have a few men as well, but primarily women. Some of them as young as 15, young girls. Now, what is the basis for vicarious liability? Well, it is primarily employment if an employee is doing the job of for an employer, working for an employer, but does it in a way that is unauthorized, different from the way the employer wanted, but still doing the job. In other words, acting in the course of his employment is the term used, as distinct from going on a frolic of his own. in the course of his employment, as distinct from going on a frolic of his own. Was Dr. Bates on a frolic of his own? Well, I suppose you could say that in a way, but he was doing the job that he was paid for by Barclays Bank. In other words, he was filling out these medical reports, for each of which he was paid. He was paid separately for each one. And these examinations were held at his home, where he had his surgery as a GP. He was an NHS GP, but it seems that his ordinary NHS practice had ceased by the time he did this work, and he was doing this work for Barclays Bank, for a South African mine, and for one or two other institutions, very similar sort of work. And in each case, he was paid on a piecemeal basis. He is paid for each report. Anyhow, at first instance in the High Court and on appeal to the Court of Appeal, it was held that Dr. Bates had indeed been acting almost as if he was an employee of Barclays Bank. Wasn't officially an employee of Barclays Bank, no. But he was acting as if he was. And on that basis, the court found Barclays Bank liable to these 126 claimants. However, on appeal to the UK Supreme Court, that was reversed on the basis that Dr. Bates, after all, had his own practice. He wasn't paid a retainer. He was paid individually per report, and therefore he was not acting in any way like an employee, and therefore Barclays Bank were off the hook. And these 126 claimants lost their case in the end. Having won the first two rounds, they lost in the Supreme Court. Well, what sort of setup is that? How could the result be so different on facts that were not in dispute? There was no argument on the part of Barclays Bank that Dr. Bates had not molested them. That argument was not raised at all. It was purely on the basis of whether Barclays Bank should be responsible for Dr. Bates's actions, on the basis of vicarious liability. And we have spoken about this in a previous video, the concept of vicarious liability, going back to the lovely old case of Limpus and London General Omnibus, 1862, where Mr. Limpus was injured in a horse-drawn bus accident because the driver of his bus was racing another bus, and there was a collision and Mr. Limpus was injured. Was he limping? I've often made that joke myself. Bernard says, was he limping? The name Limpus. I'm not actually sure what his injuries were, but it's a good way of remembering it. And the thing is that those bus companies were known, or should I say the bus companies knew that their drivers were racing against one another, overtaking and causing accidents that way. And they had a card issued to all their drivers, which was prominently placed in the cab of the driver, cab of the bus, saying no racing, no overtaking, and so on. And so when it came to court and the bus company was asked for their defense, they said, well, how could we possibly be responsible for this? After all, this is exactly what we told the driver not to do. That's what caused the accident. Exactly what we told him not to do. So it can't possibly be our fault. But the court said otherwise. They held the bus company responsible because they said, well, yes, maybe you instructed your driver not to do what he actually did and what caused the accident. That is true, but he was not on a frolic of his own. He wasn't driving the bus down to Brighton, for example. He was driving the bus on his route. I think it was in central London, Euston Station, around there. He was driving his bus along the approved route, but not in a manner that was approved by his employers. That's true. So, therefore, he was, or the bus company was, held liable under vicarious liability. In this case, the case of Barclays Bank, the UK Supreme Court decided that Dr. Bates was not an employee or in the nature of an employee at all. But what they did not consider is that the law of vicarious liability is not limited to employment. It can equally apply to agency. If an agent acts while doing a job for his principal, if an agent acts negligently, the principal will be liable. If Dr. Bates was not an employee of the bank, I would say he most certainly should have been considered to be an agent, and therefore the bank should have been held liable on that basis. Agency was mentioned in one word, one sentence, only to be dismissed completely, never considered at all by the Supreme Court. What does this tell you? This tells you that the law is in a state of disarray. In other words, disorder, or to put it very simply, in a mess. It's not my words. That actually was said by Lord Neuberger. Not of this case alone. He was not talking about this case. He was talking about tort cases in general, tort being the biggest area in the civil law, biggest area by far, including all types of negligence, as well as vicarious liability and, well, most road traffic cases. So, but the real question is, why is the law in such a state of disarray? More next time.